Hello everyone, we are back with the session. Thank you so much all of you for joining us, and once again we are extremely apologetic for the inconvenience you have had to face, but as you people asked for, we have shifted to Zoom, so hopefully our experience over here is going to be seamless. Once again, we'll start the session. Our resource person is already here with us, but before I do that, I request every single one of you to kindly send a quick hello or good morning or present in the chat box so that I can know that all of you are here and you're present with us and we can start the session. So just quickly do that so that we can start with the session. Thank you so much, guys. Thank you. I love to see you all engaging with us. And since you all have made us come to Zoom now, you can also utilize the reactions over here, which we are going to see. You can send us a thumbs up, and we will be able to see that you are here with us. So let's engage with each other. Okay, I can see the reactions. Thank you so much, guys. Thank you. Yes, Nihal, it's great to see you again as well. Hi, Siddhant. Shubh, Manisha, Ashi, Tanya. I'm so glad to have you all here. And thank you so much for responding. I can see more and more of you joining us now. So without much further ado, I will initiate the session that you all have patiently been waiting for, and I have been looking forward to, bring to you. Yeah, same here, Soumya. Soumya is one of my most favorite persons in this chat now. She's very active and always enthused, just like me. So thank you so much, Soumya. Thank you, Anushka. Let's start the session. So without any further ado, the first and foremost thing that we are going to do is introduce the guest for this session, Mr. Adhish Sharma. Adhish sir, I hope you are here with us.
Yeah, I'm here. Hi.
Hi, sir. Hi. Everyone, we have with us Mr. Adhish Sharma. He's a principal associate with Khaitan and Company, Khaitan and Khaitan. And he's here with us to take this boot camp. He does a lot of advisory work in relation to conflict resolution, dispute resolution, arbitration, corporate matters. That is his specialization. In addition to that, sir has taken his degree from Amity University, and he's here with us this morning. Now we are touching afternoon, so I'm going to shift to the word afternoon. He's here with us to take this session, and he has been patient enough to wait. So thank you so much for that, sir. We really appreciate all the patience that you have shown. And on that note, I will hand over the mic to you so that we can start with the session.
Good afternoon. I hope I'm audible. If I'm audible, just if I can get a thumbs up from you, Rashmi, and yeah, okay. So hi everyone. So I've been called for this session, which is mediation and client counseling. So just a basic idea of what mediation is and what division of law mediation comes under. It is basically alternative dispute resolution. Now, this is a process which we use in practice of law to resolve disputes without litigation, that is without going to the courts. Now, why we do that is because litigation involves a huge cost. Now, that cost can be borne by everybody, but not by a person who does not have means to actually go forward and fund that litigation. So then the statutes deemed it prudent to introduce a concept of mediation. Now, why mediation is because it is an unbiased method where a third party helps the stakeholders involved to resolve the dispute by communicating, negotiating the disagreements, and amicably resolve the disputes. This is a process which actually criticizes that statement which has been heard by all of us from a long time, maybe not as a law student but prior to being a law student, is that justice delayed is justice denied. So this is a process which is a very quick process, and it helps resolve the disputes very in a very efficacious and a quick manner. Now, what is the importance of ADR? it has harmonious settlement of disputes, it is speedy disposal, it is reasonable, it takes less time, and you know there is an organization called Samadhan, which functions with the Delhi High Court. Now, why I'm mentioning this organization is because this organization actually spearheaded the concept of mediation at a time where mediation was not recognized. It was not recognized in the Commercial Court Act. Commercial Court Act was not introduced. They have been working on this aspect where they actually have an option of people mediating their disputes before going to the court. Anybody can apply to Samadhan, go there, get their disputes resolved, and ultimately get an amicable settlement out of their dispute, which probably in litigation would take some time, because as we all know that there is a procedure involved which is there in litigation. Now, we got hold of a small video on the website of Samadhan, which I think would sum up what mediation is all about, and would actually be a little interactive for all of you to also understand that how mediation works and what mediation is. Then we'll delve into details of what mediation is. Rashmi, I would please request you to have that video on.
Absolutely, sir. We will play the video.
So this is a video which we're using from the website of Samadhan. So we thank them for having this on the website. It is not audible. Rashmi, this is not audible.
Yes, sir. Just give me 1 second.
Did you hear me? I want a divorce.
You won't even get
Conflict of child maintenance and custody.
I want a divorce. Custody. This. Did you hear me? I want a divorce.
You won't even get
Conflict of child maintenance and custody.
I want a divorce. My house. He's my father.
You stole my brand name.
Trademark and IPR
You
disputes.
stole my
This is
brand.
our copyright.
You stole my brand.
The project has
been a
not
breach
been
of contract.
Commercial
If
disputes.
you
It would take my side. This is my land.
This is my
No,
land.
it's
I am
not.
the
This is
landlord.
my land.
Property disputes.
Right, this is my land.
You are a
This
squatter.
is not
This is
your
my
land.
land.
This
How
is my
dare
land.
you?
Right.
My
This is
And
my land.
several others. For matters like family dispute, matrimony, commercial or property amongst others, you can approach the Delhi High Court Mediation and Conciliation Center, also called Samadhan.
Samadhan? Is that another court?
Not at all. Samadhan is the Delhi High Court Mediation and Conciliation Center. Mediation is an alternative dispute resolution forum. In fact, the court mandates and encourages parties to resolve their disputes through mediation. Trained mediators at Samadhan facilitate the parties in resolving their disputes and/or differences.
We are not judges.
We facilitate you in settling your disputes through a simple, flexible, and informal process.
You are in control of your own disputes and not a third party.
But how will this help us?
While your lawyers speak for you in court, here you get a chance to speak for yourselves. You can communicate in a real sense and address underlying conflicts to arrive at a commonly acceptable solution.
So, do we have to pay?
No, court-annexed mediation is free. It saves costs, energy and precious time. In fact, if your matter gets resolved, then the court fees paid by you will also be refunded.
What we say here, can the opponent use it in court as evidence?
Don't worry, this is a confidential process. You can open up and talk to your heart's content. The court cannot summon me, and our discussion remains strictly confidential.
But what if he refuses to cooperate? In the past he has.
Let's not think about the past. Let's work on improving the future and restoring broken relationships.
What if we don't reach a settlement here? And if a settlement is reached, what is its sanctity?
It's voluntary. If no acceptable solution is arrived at, you can always go back to court. The case shall continue from the stage you were referred to, Samadhan. If the settlement is arrived at, it merges into a court order and binds the parties. And that's not all. It immediately puts you in control of both the dispute and resolution. The law mandates it, and the courts encourage it and endorse it. Through it, you can communicate in a real sense with the other side, which you may not have done before. The process is confidential. The procedure is simple, and the atmosphere is informal.
It is voluntary, and you can opt out of it at any time if it does not help. It saves precious time and energy. It saves costs on what usually becomes a prolonged litigation. It shows you the strength and weaknesses of your case, which helps you find realistic solutions.
It focuses on long-term interests and helps you create options for settlement. It restores broken relationships and focuses on improving the future, not dissecting the past. You opt for more by signing a settlement that works to benefit both you and your opponent. And at the end of mediation, you can actually shake hands with your opponents and wish them good health and happiness. A court case can drag on for years. I feel happy when the same issue gets resolved between the parties in just a few sittings.
I hope you are satisfied. Please read the settlement, sign it, and we shall submit it in court.
I'm glad our differences have been resolved. How we can complete this project in time.
We were able to reach an amicable
We
settlement.
can live as brothers again.
We can both live on this land peacefully.
We can be a family again.
With the divorce finalized, we can move on with our lives and yet be friends.
Samadhan also conducts pre-litigation mediation at a nominal cost.
And the parties get all the benefits and advantages that mediation brings with it.
I hope you would all have gotten an idea of what mediation is. Now, this was only Samadhan, which is attached to the Delhi High Court. But then, of course, there are other mediation centers all across India with different high courts who are working in that direction. And of course, there are private mediation centers as well. Now, the concept of mediation is not new. It's an historical concept. It's a historical concept. It has been used time and again in the history, and we find its references in the history, like from Lord Krishna mediating between Kauravas and Pandavas in Mahabharata, to the family elders. All of us here would have family elders. There are disputes in some families, unfortunately, which happen, and those disputes don't travel to court, but they travel to the eldest most member of the family, or a group of people in the family who then sit together on a table and get those domestic issues resolved. And of course, then there is a concept of panchayats. Panchayats have been doing this since ages in villages of rural India. It is nothing but mediation, because all of them sit together, find a amicable solution, and then it is actually applicable on everybody, and everybody follows that decision through and through. Now, mediation is actually the oldest and historically the most effective way that societies have resolved their disputes and those differences outside the courts, and not getting into prolonged litigation. Today, it is in fact, after the pandemic, it has in fact become the first choice of many corporates to actually first try and mediate their disputes, and then if they don't succeed in that mediation, then go for a court case or something like that. Now, what are the types of mediation? There are actually 3 types of mediations which are currently in place. That is, one is court annexed mediation, then there is court referred mediation, Then there is private mediation. Now, what is court annex mediation? This applies to cases where cases are filed in the court or are pending in a particular court. The mediation services that are provided that by that particular court are a part and parcel of the same judicial system. Now, how they are part and parcel of the same judicial system? There are certain rules which the Supreme Court and the High Court, in pursuance of Section 89 of the Civil Procedure Code, draft to conduct these mediation proceedings. Now, mediation centers have been established by Supreme Court. Now, like we saw an example of Samadhan being established by the Delhi High Court, there are various other examples. Now, and of course, district courts have their separate mediation centers, and consumer courts have their separate mediation centers. So all these different courts have their mediation centers where parties can be referred to and go and resolve their disputes amicably. The procedure is within the court complex. Like, for example, in a district court, the mediation center would be in that particular court complex. For a high court, it would be in that particular complex. So that is how these court annex mediation process works. And when the mediation is finally concluded, there is a process by which a settlement is arrived at, and it is mutually signed by both the parties, and it becomes binding on both the parties. Now, what is the second type is the court referred arbitration. Now, what is court referred arbitration? Now, it applies to cases where the court, if it deems fit, like mostly we see this in cases under Section 138 of the Negotiable Instruments Act, which is the cases where checks are bounced. Now, this happens very often in business transaction, that somebody gives you a check and that checks get bounced. So and this invites a criminal liability, and it's a quasi criminal trial which happens. The accused, that is the person who has given the check, has to be present in the court. So now in some cases it happens genuinely that due to certain circumstances those checks get bounced. So then the court also sees the bona fide of the party, and then refers them to the arbitration. So now this is also, rules are framed under Section 89 of the CPC. And in a case which is, we'll give the citation later on, it is 2010-8 SCC 24. This also finds a mention in the brochure of this event. Afcons Infrastructure Limited versus Cherry and Varki Constructions. A dispute referred for, which states that a dispute referred for mediation by the court will be deemed to be a reference to Lok Adalat, and the procedure prescribed under the Legal Services Act will apply, as if the dispute was referred to a Lok Adalat under the procedure of provisions of Legal Services Act. The control and jurisdiction over the matter is retained with the court, and the mediation settlement reached before the mediator is placed before the court for recording the settlement and disposal of the matter. Court applies the principles of Order 23 Rule 3 of CPC and pass a decree and order in terms of the settlement regarding the subject matter of the suit and proceedings. Now let's halt here for a while. What is Order 23 Rule 3, and why emphasis on Order 23 Rule 3 in this judgment? Now what happens is, now there are two types of cases which generally are filed. One is 138, like I mentioned, that does not attract a court fee. Now there are recovery proceedings, which is a normal civil suit, which all of you might have heard, involves a substantial court fee, which is different in different states. It's a substantial amount. Now when I file a case, I have to pay that court fee because there is a judicial time which is spent on that particular matter. Now, what advantage do I get of settling this matter early with the party? Probably I will also, after that prolonged litigation, maybe get the same result which I get from the mediation, but I have to be given an advantage. So this is where Order 23 comes in. Once you settle a dispute in mediation, your entire court fee, I repeat, the entire court fee, 100% of the court fee is refunded back. So the court also encourages that if parties settle dispute outside court, they don't waste the precious judicial time, they do not add to the backlog of cases in the country, which it's already a problem. They are benefited, they are given an advantage, and that court fee which is deposited at the time of filing that particular case is refunded back to you, 100% of it. Now, then there is a concept of private mediation. Now, what is private mediation? When parties undertake mediation individually, independent of court proceedings, it is termed as private mediation. Now, like you would have heard in that video, Samadhan also gives pre-mitigation services. Now, that is before going to any court, before filing any case, in a confidential manner, you can sit together with the party who you are disputing with and settle that dispute. I just happen to have seen somebody saying that I have resolved my case in Samadhan in Delhi High Court mediation cell, and court has given me the statement of refund of court fee, but from last 3 years I haven't received my court fee. How will I get that back, or where will I reach to get that? So now this is a very good question. Now this refund has to be applied for. There is a procedure, you apply for the refund with the registry, and registry gives you that refund. It's not a case where it is delayed, you have to apply and get that refund. Now somebody says in most cases I have seen mediation getting failed because of opposite party either doesn't come or escalates the conflict. In these circumstances, what should be done? Now it's the answer to this is very simple. There is a time limit to mediation. 90 days is the maximum permissible time. After 1 or 2 appearances, if the party opposite side doesn't come, you can take the matter back to the court and proceed in the matter as per the procedure, and the mediation will be called as mediation failed. It is not a compulsory procedure that if the opposite side is not coming, or if they come on some date, and if they don't come on some date and they are delaying the matter, you have to continue with it. And there is one more question. Now we'll take questions in the end. It says that what is will the private mediation bind the court? Of course it will bind the court, because you'll, after the mediation, you'll enter into an agreement which will be binding on both the parties. It will not be that you speak in a mediation and there is no agreement which is entered into. You have to enter into an agreement, and if that agreement is broken by either of the parties, then it will have its own remedy. So that's how it continues. Now, is there a legislative recognition of mediation? Yes. Now I'll name a few acts. Industrial Disputes Act 1947 provides for it. Section 89 of the CPC provides for it. Arbitration and Conciliation Act 96 provides for it. Hindu Marriage Act provides for it. Companies Act provides for it. And as a matter of fact, these days, a lot of NCLTs in disputes of oppression and mismanagement, which are disputes between the management of companies, are actually referring parties to mediation, as they understand that it is just a fight of ego, or just a fight between two individuals at the cost of a company which is running through many years. So they actually, on the very first date, or maybe the second date after a notice is issued, they actually prefer the parties to have a mediation process. This is, I'm talking about matters under Companies Act, not under insolvency. I'm not under insolvency. This is under Companies Act, oppression and mismanagement. Now we'll discuss this in detail. Now there is a section 12A of the Commercial Courts Act. Now that amendment in 2015 actually recognizes that before any commercial dispute goes to a court, or if any company goes to a court, they have to first go and do mediation, which is a mandatory pre-mediation process of 90 days. I'll delve into details a little shortly. And of course, section 32 of the RERA has it, and Consumer Protection Act has it. Now, there are many private institutions which have come forward And in addition to the mediation centers already established by various courts and district courts, they also provide the services of uh, as services as a forum of an alternative dispute resolution. They assist parties in a confidential manner with several protections in place, like a non-disclosure agreement and all those things, to assist parties in getting their disputes resolved amicably rather than going to courts. Now, some of these institutions are ASSOCHAM, ICADR, Center of Advanced Mediation Practice, then Indian Institute of Arbitration and Mediation, India International ADR Association, Mediators India Chennai, Foundation for Comprehensive Dispute Resolution, then there is META, then there is Samadhan, then there is Alternative Dispute Resolution Center Kerala. Now, what are areas where mediation cannot happen? Now, again, that judgment which AFCONS I had mentioned states certain categories where mediation cannot happen at all. So if tomorrow as a lawyer you come across such a case, you cannot advise your client for mediation in these type of matters. It is very clear where the suits involve public interest. Now, public interest litigation, PILs, they cannot be resolved through mediation. That's not a process which can be gone into through mediation. Now, election to public offices, can that be resolved through mediation? No, that cannot be resolved through mediation. Suit for grant for probate or letters of administration. Now, when somebody dies, a probate has to be taken from a court. Whether then while that probate has been taken, there is certain objection by legal heirs. Can that be resolved in mediation? No, probate has to be taken through a court. Then allegations of fraud, fabrication of documents, forgery, this cannot happen before a mediator. Mediator cannot see whether a document is forged. Forensic science is not something which a mediator does. Protection of courts, like, if there is a claim against minor, that juvenile has to be protected. Then a mentally challenged person, if he has to be protected, mediator cannot grant such protections. So for that, you cannot go to a mediator. Then suit for declaration of title against the government, for that, can you go? No, you cannot go. Then cases involving prosecution for criminal offenses, can you go for that? No, you cannot go for that. Now, if these categories in this judgment, AFCON's judgment, are held to be cases where mediation cannot happen, there is a list which has been specifically comprehensively given in that judgment where you can go for a mediation. Now, what are those kind of cases? Now, those kinds of cases are trade, commerce, contracts, corporations, property, construction, banking, financial, shipping and real estate disputes. Companies having disputes in trade and commerce, in contracts which are other than the nature mentioned in the list above, can be resolved. Matrimonial disputes, child custody cases, maintenance cases, division of family property, all those cases, of course, division has to be done by orders of the court, but of course, parties can amongst themselves sit and discuss that what kind of division they want. Like, for example, if somebody is staying in a 2-story house and it has to be divided amongst 4 people, how that 2-story house will be divided amongst 4 parts. Now, ultimate order will come from a court only of partition in a partition suit, but that arrangement can be executed between the parties of how these disputes have to be settled. Then all claims and torts, they can be resolved through mediation. Then all consumer dispute. Now, we saw a phase of pandemic post 2020. Now, we as practicing lawyers, what we also observed is, what used to happen is, in mediation, it is generally requested by the mediators that parties in person should appear. Rather than advocates appearing for their parties should also be present. Now, in some cases, it happens where parties unable to travel, then they authorize somebody, they give a power of attorney to somebody, or they tell their advocates only to appear because of XYZ reason. Now what we saw post pandemic is development of an online ADR system. It was there prior to that also, but it developed very uh, rapidly during the phase of pandemic, and the disputes started getting resolved in a very quick manner, because the the lag between a message being conveyed by a lawyer to their respective clients became less, and those parties, by the mode of this virtual presence, was available directly interacting with the parties. All those sessions had the same privacy norms, which privacy norms are there as are there in the physical mediation meetings, and people were actually very uh, getting their disputes resolved amicably. Now, of course, with kind of with new uh, things come new challenges. There have been challenges in between, like people have not been tech savvy, they don't use a particular software, or are not friendly with a particular software which various courts use. But slowly and steadily people are getting used to it, and even now, after physical courts have resumed at a lot of places, uh, uh, barring a few forums, mediation still gives you an option of being done virtually, and to the benefit of parties who are not residing in India, because there have been travel restrictions in the past. They can actually, from their country of residence, join the mediation proceedings and see an amicable dispute. Now, uh, Rashmi has also prepared a small presentation for this event. We'll have that presentation on, and Rashmi, I'll let you know when to stop the slides. Can we have that presentation on, please? In the meantime, Sushil, you had some question. Your hand seems to be raised.
Yeah, can I ask the question now?
Sure, sure.
Yeah. Okay. Maybe if you please tell me, maybe you will be covering this later. But you mentioned the section 12A of this Commercial Courts Act.
I'll be covering it.
Huh? Okay, you'll be covering that. I'll ask you then. And one more thing, I joined a little late. Did you mention anything about the Singapore Convention?
No.
Not yet?
No.
Okay, because you mentioned so many acts in which already mediation is there. So how the Singapore Convention might affect these, if you can mention it later during your...
Sure. Rashmi, can we have the presentation on, please?
Yes, sir. We are just going to put it on the screen. Sir, is the screen visible?
Yes, yes.
All right,
So
sir.
now, what are the types of mediation? Then what role does a mediator undertake in each type of mediation? There are three types: transformative mediation, facilitative mediation, and evaluative mediation. Now, if we can have the next slide, please. Transportive mediators will not offer the previous one. Transportive mediators will not offer an opinion on the strength or weakness of a party's case. This allows the parties to be confident in their decision. So they never tell the party that their particular case on merits, if it goes to a court, will particularly be lost or does not have enough material to actually succeed in the longer run. The mediator will actually follow the lead of the parties and encourage the parties to continue to participate. And this kind of a mediation process gives parties the control over the entire process rather than anybody else controlling the process. The transformative mediator guides the parties as they move towards settlements rather than act as an authority and figure the answers. Now, then there is another method, facilitative mediation. Next slide, please. Facilitative mediator seeks a resolution that both parties are fully comfortable and agreeing to whatever is set to in that particular proceedings. Facilitative mediation allows the parties more freedom to shape the outcome of the mediation and not have an evaluation of their case driving the mediation. Facilitative mediators they do ask questions that help parties articulate their underlying interest that are driving their demands. He may, from listening to both the parties, actually have questions for parties so that they can actually eventually end up settling the matter rather than prolonging their dispute. This gives the parties a deeper understanding of what they actually need to settle and gives the party the ability to be creative with their suggestions, because the person who's sitting as a mediator can be a retired judge or a practicing advocate with having a number of experience. So he can actually better facilitate the party in terms of coming to a particular point on the table that yes, this is what we are concerned about and this is what we have to settle, and this is how we should take this process forward. And of course, at the same time, he will give space and encourage the parties to actually acknowledge the position and interest of both the parties. Now, the third type is evaluative mediation. Next slide, please. Can we have the next slide, please? Evaluative mediation. So mediator will be assessing the situation at hand at all times. Everything mentioned by the parties will be considered and evaluated. Then this ensures that the mediator is not missing anything when they make their evaluation. After listening to the parties, the mediator would evaluate the strength and weakness of the position and offer an honest evaluation to each party's case. Now, this evaluation is not a court decision. This is his personal evaluation of the matter at hand. It can be different when it goes to the court, but of course, he, as a mediator appointed, will give parties his mind of what he thinks on the facts of the matter, where this mediation is going. Now, he can also this kind of a mediator also gives the recommendation what kind of settlement can go forward, but rest assured, this is all informal. If parties do not agree to his suggestions or they think otherwise, they are advised legally otherwise that their case has a better standing if it goes to the court, then they are actually they can actually call off the mediation and not go ahead. And also, that mediator cannot force his thought process on the parties. Now, what are the qualities of a good mediator? What if tomorrow some of you are aspiring to be a mediator, what qualities you should possess. Can we have the next slide, please? Next slide, please. I see some people writing in the chat box. So of course he has to be calm, good listener, empathizing. He has to be alert, non-judgmental. He doesn't have to judge. In evaluation, he's not judging. He's giving his peace of mind based on the facts presented to him. He cannot be biased on one party basis his decision. And if at all he is, you can request the court that the mediator is biased and is not listening to both the parties equally. You can actually have the mediator changed. He should be perceiving. He should be creative, communicative, persisting, patient, solution oriented, and flexible. Flexible is most important, because if the mediator is flexible, he can patiently make the parties understand what is the end result, and how he can how the parties can actually resolve their disputes, rather than prolonging it. Now we'll go, there are further slides, but we'll go to them in a few minutes. Now, how is the process initiated? Now, on the very first day, when the court refers you to a mediation, there is a particular, if it is a court referred mediation, there is a particular date which is given by the court to go before the mediators and present your case. If it's a privately instituted mediation, if it's a pre-dispute mediation, then of course you approach the particular mediation center, then the mediation center gives you the date. Now, what is the process involved? Now, if we can have the next slide, please. Now, first is introduction and opening statement, then actually understanding what the problem is, understanding the interest of both the parties. We'll have the slide up in a few minutes. Defining the problem, creating options, evaluating options, then of course settlement or non-settlement. Mediation does not mean a guaranteed settlement. It of course is a settlement which will, if achieved, it can go ahead. If it not achieved, then you go ahead with your case. If we can have that slide back, please. Next slide. Now, this is what I just said. Now, stages of a mediation process. Now, stages are opening statement, joint session, separate session, and closing. Now, introduction and opening statement. The mediator will give an introduction with his qualification, establish his neutrality, and repose the faith in the mediation process. The mediator will request the parties to introduce themselves. The motive is to create actually a constructive environment, and the mediator will then establish the control over the entire proceedings. And then there is no standard set of rules which have to be followed. This is not an arbitration. The parties can actually define themselves. They can, some in cases of companies, they might have to take instruction. In cases of families, they may have to involve a number of family members. So procedure is actually dynamic, and it depends from arbitration to arbitration. Now, what is an opening statement? Next slide, please. The mediator opening statement is intended to explain the parties, the concept, processes, and the stages, the role of the mediator, advocates, and parties, and the advantages and ground rules. The mediator confirms from the parties in writing. There is a acknowledgement taken that they have understood the process, and gives them the open opportunity to get their doubts clarified. And then the statements are also taken from the negotiators, and this is followed up by any difference of opinion that may arise, and then that difference of opinion is actually settled. Now, then there is an agenda which is set. agenda is set by the mediator. We'll stick on this slide, please. Setting the agenda is an important duty where mediator sets down the agenda, what will be the agenda involved for each particular mediation hearing. And then while setting it down, the parties can individually see that in what agenda, in what particular head they have to make their case good or negotiate with the opposite side and eventually come out and come out and settle the matter. Now then next slide please. Then it is joint session. Now in joint sessions what happens is you gather every information is gathered by the mediator. He understands all the facts and issues, evaluates the roadblocks involved, and provides both the parties to hear each of them out and understand each of their perspectives in an amicable manner. Then there is a concept. Next part. Next slide. Next again. Next. Then there is separate sessions. Separate session is where mediator will separately sit with both the parties and understand in private, because there may be certain issues which the parties would not want to at the first instance discuss with the opposite side. Separately discuss it with the mediator and give them their peace of mind, so that mediator can actually maintain that confidentiality and of course understand the dispute at a deeper level from the prospect of both the parties, and encourage a generation of opinion, or maybe give an evaluation of his own mind by way of an evaluative mediation. Give his mind to say that what actually he feels about their case, and it is of course non-binding and non-judgmental. He just is giving his peace of mind as the parties are giving him, making him understand what they actually aspire or what they want to achieve out of this mediation process. Now in the end, of course, it's closing is reaching a settlement. Reaching a settlement is that next slide please. Reaching a settlement is proper agreement which is signed between the parties, and if there is no settlement between the parties, then there is a closing statement which is recorded that parties could not settle their dispute, and they are remanded, they are referred back to the court, and their case the case is mm, the case is again open for going forward. Now, like a gentleman was just mentioning about pre-institution of mediation. Now, this is what actually a session is, what I just spoke about. This is how mediation is conducted. Closing can be of course, two types. Like I said initially, either the matter is settled or the matter is not settled, and it is referred back to the court. Now, in 2015, there was an amendment brought about in the by way of a Commercial Court Act, which was introduced, and there was Section 12A. Now, how it came about was that there was a legislation which was first highlighted in the 188th report of the Law Commission, with the made which says that the transactions which are we can stop sharing the slide please. So the Commercial Court Act was introduced actually to establish commercial courts in India for adjudication of commercial disputes and disputes which are actually high stake contracts of commercial nature, to actually boost foreign investor confidence in India and to improve the concept of ease of doing business which foreign businesses have with India, because a lot of foreign businesses face a lot of problems while dealing with third-party contractors in India. Third-party contractors actually uh, give a lot of problem to these foreign entities by not paying them in time, by actually delaying their payments. So what is happening is, with the introduction of what has happened with this, we'll just broadly cover this. Now, the definition of commercial dispute under the Act is broad, and it covers a commercial transaction and includes dispute arising out of intellectual property rights as well. In 2018, the Act was actually given more clarity, and a procedure was introduced for a mandatory pre-institution of mediation. The Act provides for speedier adjudication of commercial disputes of a specified value, and specified value under 2(1) of the Act is 3 lakhs. A dispute above 3 lakhs is if it's commercial in nature in terms of the transactions which are defined therein. Then it is considered as a commercial dispute between the parties, and it is then bound by the Commercial Court Act. Now, what is the procedure for that pre-institution mediation? Now, that procedure is set out actually in the Commercial Court Pre-Institution Mediation and Settlement Rules 2018. As per the rules, the plaintiff, the person who's filing the suit, must file an application with the State Legal Services Authority or the district, as the case is, District Legal Service Authority constituted under the Legal Service Authority Act, to initiate mediation. Once an application is received, the authority then issues notice to both the parties to appear before it within 10 days and give consent to participate in the mediation. Now, that consent is very important. Now, if the parties don't give their consent, then a report is generated by the mediator that parties are not willing to settle, and the matter goes to the court. Now, the advantage of advantage which the Commercial Court Act brought in was also the fact that the Commercial Court Act establishes a timeline for a dispute to be settled. Now, that timeline is well defined. Therefore, if that mediation of 90 days, this is a 90-day mediation period, if that within that 90 days, if the dispute doesn't get resolved, then the parties are referred back to the court, and the report which is generated is called a non-starter report. Now, initiation is, the party has to make an application with a fee of ₹1,000. The authority, having regard to the territorial and pecuniary jurisdiction of that particular commercial transaction, issue notice as per Form 2. If no for receiving a response within 10 days, and if no response is received from the opposite party, a final notice is issued to the parties to either appear or not appear. And where the opposite parties, after receiving a notice, they may seek further time to engage somebody or to actually have somebody guide them in the particular matter, then they can get an adjournment of 10 days. When both the parties appear, then a date is fixed, and the proper mediation process, as I have explained earlier, follows. And this is the duty of that particular mediator, to actually try and resolve this dispute within 3 months or 90 days. 3 months is 90 days. If it doesn't happen in the 90 days and the parties are on line of a settlement, then at the mutual consent of both the parties, it can be extended by 2 months, not more than that. The idea behind this is to not actually prolong this process into a process by which maybe one party can take advantage of a situation whereby they can, just by their lackadaisical attitude or their attitude to prolong the litigation, prolong this process. Now, Sushil, you wanted to ask something here?
Yes, since you were talking about the Section 12A of Commercial Courts Act.
Yeah.
See, some thoughts on this. One is, it does not help that, despite the word is, it shall, the word is used as shall. But despite that, different high courts have given different interpretations. I think the Madras High Court has said that it is not mandatory, it is only directory. And some other high courts have said that it is mandatory. So a lot of confusion is there about this having to go for mediation. That is one thing. Then secondly, there is a proviso, right, that where urgent relief is sought, then you need not go for mediation.
So that in that cases, but it is by the leave of the court. So you have to actually take the leave of the court, and in the cases where now off lately, like in Delhi also, there were the courts were not there for commercial courts were not established at the district court level for IP disputes. They have recently been established. Now, what happens in an IP dispute is, because the business is being affected of a particular party, that comes under the category of urgent relief for taking an injunction. So because if you institute a pre-mediation in such cases where an injunction is mandatory for you to actually get some relief, then you cannot possibly give them a 90-day notice in spite, because before initiating a suit for injunction, you for a IP injunction, you would have already issued a cease and desist notice. A party which does not actually answer to your cease and desist notice will actually do nothing if it comes to a mediator and desist from using your IP rights. This is just one example that I am giving. So in such cases, you actually have to go to the court first, and after getting probably an injunction in your favor, maybe right, because in most cases it is ex parte. So if the opposite party then comes in and the court suggests that this matter can be mediated between parties, because ultimately is a mitigation of damages, then that damages can of course be referred to mediation at that particular stage. So not all commercial disputes mandatorily can go into mediation, but of course where there are disputes which can readily go into mediation, contractual disputes between regular operational creditors of a company and the company which are company which is a going concern making profits, that can of course be done in mediation first, and thereafter be referred, and thereafter be taken back to the court.
No, fair enough. See, the examples you are giving is cases where there is really a genuine urgent relief being sought.
Yes.
But what is actually happening, what we are facing now, is that just to bypass this requirement of Section 12A, Lok Adalat, people are filing some frivolous urgent relief, security for costs or some silly thing like that.
But let me tell you, in my limited experience of what I am sitting here before you, those reliefs are actually analyzed by the courts very carefully, and if those reliefs are not urgent reliefs, the suit is the parties are directed to withdraw their suits and to refer the dispute first to the mediation and then come back to the court. This is what I have also practically seen happening in courts. Of course, it will differ to court and court, because ultimately it's the judge who's sitting in the court and has the power to actually follow this, unless a ruling comes from the Supreme Court that this procedure has to be followed come what may. Unless like the other judgment where they have defined what matters can be mediated and not mediated, they come out with a judgment where they also define that what is urgent and what is not urgent.
Yeah,
that has to be defined. Act doesn't give that differentiation, unfortunately.
So there are some precedents already that they have to be referred back to in case the urgent relief.
But ultimately it has to come from the Supreme Court.
That's the problem we are facing.
Yes, because what happens is, so now you may have something in Chennai, but that is not there in Delhi. So the Delhi, say for example, a 30 Hazari court in Delhi, even if you with that urgent relief application go with the judgment of that particular high court, he will say that nothing like this has come from the Delhi High Court, so I will follow what is said in the act. My wisdom says that this is not an urgent relief, so you first do the mediation, or you first do the mediation and then come back for the case. Of course, then that follows to a hierarchy of appeals, and if it, of course, ultimately it does nothing but it delays the matter of that particular party only. Because it's very simple. If the party does not mediate, a non-starter report goes. It's very simple. On the very first day, you have to give a consent. Even if one party does not give consent to a mediation, if there are a number of defendants involved, the mediation doesn't go forward. It is referred to the court.
Yeah, actually, it doesn't make sense why they do it also, because they always have the option of
So we'll
they
go
are
ahead.
doing it. It's become
We'll go ahead from here. Pradipta, you want to also ask something? Then we can go ahead.
Sir, it will be better if you can share your slides as previous one, because I'm taking note from that.
We'll request somebody to share it on the email where they are sharing it. Okay. Rashmi, that can be shared, no, with them, because we no longer will be working through this.
Sir.
Yeah.
After the event.
Yes, sir. All the material will be shared with the participants post the bootcamp.
Okay. Now, like I was saying, there is an absence of any comprehensive legislation on mediation in India. The Supreme Court most recently, in the case of M.R. Krishnamurthy and New India Assurance Company Limited, the citation is 2020-15 SCC 493, has directed the government to actually consider the feasibility of enacting an Indian Mediation Act. Formalizing mediation through legislation will actually make that procedure uniform. Like it is different in one court, different in another court. A comprehensive legislation providing for institutionalized framework for mediation will actually also give more clarity, because some courts follow some procedure, some courts follow some procedure. Now, if that legislation is there for mediation to happen in a particular manner, then it will happen in that particular manner, and it will actually also encourage parties to mediate it. And it has actually, the court goes on and says that it has now become paramount that a uniform legal framework for mediation is adopted, so that there is no confusion and parties actually adopt an alternative dispute resolution rather than going to litigation directly, because once the parties are in litigation, the matter gets delayed. Now, many of you, I understand, are law students who would eventually want to end up becoming a mediator. Now, what is the qualification or how you become a mediator is something which is given in the Mediation and Conciliation Rules 2004. Now, to become as empaneled as a mediator under Rule 3 of the Mediation and Conciliation Rules 2004 by the High Court or the concerned district courts, you have to qualify as per Rule 4. You have to either be a retired judge of the Supreme Court, retired judge of the High Court, retired district and session judge, retired officer of a Delhi Higher Judicial Service or any other judicial service of the country, of legal practitioner advocate having minimum 10 years of standing at bar at that particular court, being the Supreme Court or the High Court or the concerned district court. And also it provides for experts and other professional with at least 15 years of standing, like for example chartered accountants, engineers, for disputes where you may require expertise of such people to act as mediators. Even MBA graduates, management graduates with at least 15 years of experience, and of course then people who are themselves expert at mediation, they have some certification of mediation with appropriate experience, can also become one. Now, there are certain categories under these rules which prohibit a person from becoming a mediator. Now, those prohibitions are: if that person is declared as insolvent, he cannot be a mediator. If there are any criminal charges against a particular person, he cannot be a mediator. If a person is convicted, he cannot be a mediator. Any person against whom disciplinary proceedings are initiated by the bar council cannot be a mediator. Any person who is related to the subject matter of dispute. Now, this is very, very important. Now, there can be a situation whereby you as a lawyer would be representing your client before a mediator. It has to be kept in mind that the mediator is not associated with the lawyer or the party directly or indirectly, because then it can be inferred by one of the parties, if they get to know about it, that it is a mediator, it is a process which is influenced, and uh, it will actually not see the end of the day. Now, as a law student, I would actually want to advise you that everyone should actually learn about the ADR methods, not only because these ADR methods have good future prospects, but they actually make your negotiation skills better. It is a skill that everyone possesses, but how to bring that into practice is with the experience of witnessing different kinds of disputes before a mediation cell or a ADR cell, is what you get to know. Because a husband and wife will have a different dispute. A brother with another brother will have a different dispute. A business with another business will have a different dispute. Uh, so the experience is endless, and eventually what it also teaches you is two things. One is how to resolve these disputes, and eventually as a lawyer how to eventually negotiate transactions also, because as a lawyer you would get clients who would want to enter into various transactions with various companies, who would want to negotiate various deals with various companies. Now, that is not where a dispute comes in, but of course you have to negotiate on a lot of aspects while you are executing different kinds of agreements, or different kinds of, even as a matter of fact, a clause like a notice clause in an agreement, how a notice has to be issued at the time of a dispute, may invite n number of debates, which the parties may have, because one party is saying that notice should have been issued by a particular manner, the other party is saying the notice should have been issued by a particular manner. So all these negotiation skills are developed by witnessing these mediation proceedings. So as a law student, I would actually uh, uh, recommend doing it. And it also actually, as a law student, teaches you how to empathize and how to actually see what a client, while he comes to you with a dispute, is feeling. Because in a mediation he has an open forum where he can actually tell what, since it is confidential in nature, of how that individual is feeling. So tomorrow when a client comes to you, of course not with a similar dispute, but with a dispute of a similar nature, then you can advise them better, because you would have seen that situation. Of course all situations are dynamic, but that gives you that skill to actually deal with those clients. Now, what steps you can take? There are a lot of mediation cells all across India who require interns, who actually have now started taking research assistants as research assistants as on panel by hiring them as immediate freshers who just drop out, who just clear their law degree. So you can actually look for these options, intern at these places, so that you get a better idea of how it is. So what you have to be thorough at to be a mediator, because arbitration in India has become huge. It's a great career option. People are actually only doing arbitration and not regular litigation, and they are doing good for themselves now. And not only arbitration, keeping in mind that arbitration indirectly also comes with a procedure which it follows from the code of civil procedure. So you actually have to be thorough with a few acts to, if you aspire to go forward in this particular field, is the arbitration act. CPC is your bible. CPC has to be thorough. Now the commercial court act along with the CPC has to be thorough, and of course the contract act, because majority of the disputes emanate from contract act. Then there are various other acts which then will come with your specialization. If your specialization is, for example, real estate, then you have to be good in the real estate related acts. If your expertise, if your interest develops towards IPR, then you have to be good with IPR related acts. If your expertise later on develops in some other law, then you have to actually be thorough with that particular kind of law. So you actually, you can find advocates who are more than 10 years of experience after the amendment in the Arbitration Act also, who are practicing lawyers but are also active arbitrators. They also hire, they also keep interns. So you can look for these kind of offices. A list of such lawyers are available on various websites like the Delhi High Court Arbitration Council, now the newly established Arbitration Center in Hyderabad, and various mediation cells also have their list published on their websites. You can approach these individuals, request them for an internship, request them for an articleship, and they will be most happy to help. And I would recommend that you go to a person who also practices in that particular area of interest, so that you can on one hand learn the skills of negotiation and also uh, go forward in that area of interest of practice which you eventually have. Now, we had internally deliberated and uh, made a few questions which we thought would be answering many doubts, because it has been a session which has been done in a quick succession because of some technical issues in the beginning. So I have those questions. I will we thought that these questions would come into the mind. We wanted to do that after a break, but we'll do that right away, so that since we have limited time now. The question would be, what is mediation? Mediation, like I said, is a process which is impartial and neutral third party assist disputants in finding a mutually acceptable solution. It is, again, I will say, confidential and voluntary. It is participatory. Parties have the choice to voice their feelings and are involved in creating solution to end their dispute. Mediation is a combination of willingness of parties to resolve their dispute, and the skills of the mediator are of paramount importance, which will guide the parties towards settlement. Now, why do we need it? We need it because it's a good method to resolve disputes in a quick succession, and those private relationships in private in family disputes are not spoiled because of a protracted litigation and the time involved, and in the most amicable and the humblest manner can be resolved through mediation. And Does it really help? Yes, I would say it does. It the intense conflict sometimes actually protracted litigation, and the things which one party intends to do against the other during a litigation becomes endless. We would not delve into the details, but as law students here, you would understand that once a litigation starts, it is endless. There is one allegation and a counter allegation from the opposite side, and if those parties are made to sit on a table to negotiate, most of these things evaporate and they don't even exist for the parties anymore, and they try and establish their dispute through mediation, because it's not a formal proceedings. That's very important. Now, a person who's coming to litigate is, we as lawyers go to the court to fight for these parties, but those parties are not somebody who, they are probably a businessman at a small scale, so he will only understand how he has to run his business. So he would not understand the nitty-gritties of the laws involved. He would not understand how the procedure works. So if he's made to sit at a table with a particular person who is he is disputing with, they may end up eventually getting a better settlement out of their dispute rather than a protracted litigation in courts, because eventually it takes a lot of time, and then there is a procedure involved of execution, which again takes another time, and those challenges, cross appeals, the list is endless. Now, is there a conflict between litigation and mediation? No. Some cases would actually need a judicial pronouncement, like I said, but the matters which are commercial in nature, like that judgment categorically defines what kind of matters would need judicial pronouncements. The other cases are can be settled through mediation, and that order of the mediation can be recorded before the court. And of course, that advantage of order 23 rule 3 of CPC is there, where you get the entire court fee back. Now, does that mediation does getting into this mediation affect your legal rights? No. It's an opportunity to settle the dispute. If dispute is settled. If dispute is not settled, then you have an opportunity of going back to the procedure which was actually started by you, a suit or whatever was started by you, and you go ahead with that. You don't proceed with the mediation, and the mediator says that the parties did not he will record nothing of what happened. There are no procedural orders. So like in arbitration, an order is passed on every date. In this, only an order is passed to the effect of the date which is listed, and the final order is passed only if parties reach settlement. If parties do not reach a settlement, a statement is recorded that both parties were referred to mediation, they could not settle the matter, and now they are intending to go back to the court and fight their case on merits. So whatever happened in mediation, if any documents were exchanged between the parties, those all of course are without prejudice. The documents are executed in a manner that they are without prejudice, and then they cannot be used in a court of law. Now, steps and everything we've already explained in that particular slide will be shared with you. I think the most important question, I think somebody asked this in the chat box also, that what happens to the settlement agreement executed in a mediation, whether it is enforceable, how do we enforce it? It is enforceable. Once parties reach a settlement agreement and sign on the dotted line, it becomes enforceable under the provisions of CPC or the Arbitration Conciliation Act if it has an arbitration clause, and the court can enforce that agreement if the parties do not bind by that by those terms in terms of execution or contempt. So after contempt, the actual proceedings which are initiated get restarted, and also a contempt of not following that particular settlement is initiated against the party. So those kind of things happen. So uh, does everything end in, so in the end I would say a question would come in the minds of everyone that, does every mediation end in success? So success lies partly in the advantages of the process of mediation and the skills. It also, the most important part of a mediation are the parties involved. If the party are ready to settle, nobody can force a particular individual to get into a settlement. If both the parties actually are willing to settle, then they settle. If somebody is a litigious person or a litigious organization who likes to litigate, who likes to file cases, they're good for the advocates though, on the pocket, but unfortunately they're not good for mediation, because such people end up raising conflicts, and then the mediation doesn't happen, although mediation is the most graceful way one could have. So this is what I wanted to talk about on mediation. If anybody has any questions. All right. So we also, so internship, I have already, there's few questions here about internships and everything. So internships, you can, in first year also, you can get those internships. You have to just approach the right people. Virender Pratap Singh wanted to ask something. Yes.
Am I audible, sir?
Yeah.
Sir, I had a few questions. Like, I wanted to know that pre-institution mediation and the settlement rules that you were talking about, what is that authority with which we have to file an application? Like, what
No,
is
so
it?
pre-institution mediation is now, it forms a part of the Commercial Court Act. So you say, for example, your case is of a particular pecuniary jurisdiction, and it has to be filed before a district court of a particular jurisdiction, say the district court at Fort in Bombay. So if that district court has the jurisdiction of your particular suit in terms of that pecuniary jurisdiction of the suit, then the legal services authority of that particular that very district court is where you will file an application for pre-institution of mediation, and they will follow the procedure laid down. So it will be different for different states. Like in Delhi, you have different, you have about you have different district courts. So for Patiala House, it will be Patiala House District Court, it will be a different legal services authority. And the suits which have pecuniary jurisdiction of directly going to the High Court will be the High Court Legal Services Authority, which is a different authority. So they
Sir,
will.
is the pecuniary jurisdiction like the only jurisdiction that is taken into account?
Yes, yes. So some courts in India do not have a pecuniary jurisdiction, and original side is only with the district courts. So in those courts, you will only have to go to the district court, like in Punjab and Haryana. So Punjab and Haryana, the High Court does not have original jurisdiction. So that original jurisdiction only lies with the district court. So in that, only the concerned district's legal services authority will have that jurisdiction, because you cannot institute a suit directly in the High Court in Punjab and Haryana High Court. So I don't know which state you belong to. So,
sir, I'm from Uttarakhand.
So that's Uttarakhand. I am Uttarakhand also. Uttarakhand also does not have original jurisdiction vested with the High Court. So it's like UP. But of course, I'm not sure of Uttarakhand because I don't practice there. So, but this is how it is. If the court has, the court which has that original if the High Court has original jurisdiction, then the pecuniary jurisdiction is seen. If the High Court does not have original jurisdiction, then everything goes through the district courts only, because the suits have to be filed initially at the district court level. Now, the second part of this session today that we had was client counseling. Now, client counseling is also one of the most important aspects for a lawyer, because when somebody comes to you with a dispute, they come with the thought of having that dispute resolved through whichever method. Now, this is nothing to do with the first part of the session, mediation. Mediation is an ADR mechanism. Client counseling is something which a lawyer with the years of practice that he or she is involved in, develops over a period of time, because clients are bread and butter for lawyers. So if a lawyer does not counsel their clients uh, uh, effectively and efficaciously, then such an advocate cannot practice litigation, because each client matters. Getting one particular client is very difficult. Getting and then maintaining a relationship with that client becomes another aspect. Now, why is this counseling important for a lawyer? Because counseling is all about giving your client all the information that he/she needs related to the case or the problem which he or she has come to you with, in order to make a decision of how to go forward. Because he will say, for example, some lady comes to you and says that I want to divorce my husband, or a businessman comes to you and says that, this particular entity is not giving me money. So you have to be acquainted enough to give solutions in the facts and circumstances of that particular case. Refer them to the mediation. You might be thinking that client counseling is just a little part of your job. No, it is an art which I would say that you would take an example. Many of you would have interned at various places. Now, take an example of a lawyer who is new into the practice, say a year or 2 years into the practice, with a person of 10 to 15 years in the practice. So they say it to be they say it to be the gray-haired phenomena in litigation. So as the person progresses in their litigation career, the wisdom comes to the person with the experience. You learn something new every day, and the solution orientation of such a person becomes better with the years of practice that they have. So why I gave you an example of a person who has entered into the profession and is just 2 years into the practice, or somebody with 15 years of practice, for same problem, the 2-year practice person will only have a few solutions. And I don't want to I'm not saying this as a whole, but I'm just giving you an example. But that person who has established practice about 15 years and is doing well would have a number of solutions, because he would have seen both success and failures on various situations. Whereas a person who's newly inducted into the practice, I'm not saying that this can be everybody's case. Even a 15-year-old practicing person can sometimes have a lesser experience in terms of the success or failures. But this is a general example. 90% of the time this happens, where the person with 2 years of experience would not have that kind of a wisdom which actually that 15-year practicing advocate, he or she, has to offer. So now with the passing of time, what has happened is legal profession has evolved, and the concept of client-centered counseling has became an acceptable practice, where the client comes to the lawyer, client directly comes to the lawyer, takes his assistance to make a decision. Now that decision can be both ways. Now that decision can either be in a case of a dispute, or like I mentioned in the previous session, for actually executing a new transaction, probably, say for example, to buy a property. Now you want to buy a property. Now what happens these days is there is a process of due diligence involved on the property. Now who do you go to for due diligence? You go to a lawyer for due diligence. You acquire a business, then that business has to be seen whether that business does that particular how the business has been. Say the business is about 15-20 years old, how that business has been doing in 15-20 years. You do a due diligence of that business. Who assists you in that due diligence? Again, a lawyer. Now for all, even before getting into dispute or probably starting something new, you go to a lawyer. So client counseling will also come into the play when a lawyer when a client comes to you for actually initiating a new transaction, because you have to give them solution of how to initiate that transaction and how to make that execute that transaction towards the end. Now what does a lawyer do while doing client counseling? It helps the person, the lawyer helps the person talk about, explore, understand their thoughts and feeling, and work out a possible strategy to how to execute that particular action, and eventually leading that particular client of yours or a prospective client of yours to find his solution by the queries they bring to you. Now, legal counseling is the process where a lawyer communicates advice to a client. I cannot emphasize that it is the duty of an advocate to furiously uphold the interest of the client by all fair and honorable means without regard to any unpleasant consequences to himself or any other. Now, why I'm saying so is, now somebody comes to you and says that, I have committed this illegal act. Now, if that particular gentleman has done something illegal, there has to be an evidence to support the fact that that illegal act in a particular manner by the support of evidence is not illegal. Now that assistance a lawyer has to give, but that assistance has to be legal in nature. You don't have to fabricate evidence. So you have to be very clear in terms of, while you're counseling your client, that you are not actually playing with the profession for which you've studied a long time, and you have to assist them in the most effective manner. And of course, you have to be upfront with your client in terms of the outcome of what the matter is. Now, who are your clients? Understanding what are the different types of client. Now, during the time while you start practicing or you'll be practicing, the type of clients which you will get will depend on the area of practice. But regardless of your area of practice, there will always be three types of clients which you will have and interact and have to conduct an interview at some point of time, and it will differ with the three types. Now, what are the three types? The three types are a person who's aggrieved, a person who's an accused, a person who's a witness. Now, aggrieved, when your client is the one who has violated or has been deprived of some right? So then he is the aggrieved person. He is the one who approaches. Now, then there is a second type. Your client is an accused. That means your client is seeking your advice because he has been accused by someone of something. Then there is a witness. Who is a witness? Witness is not exactly your client, but witness is the one who eventually supports the case of your client. Your witness will support your case, the opposite side's witness will support their case, and you have to, by the art of cross-examination, break that witness so that you eventually end up winning the case for your client. Now, how do you strategize? How do you get into a mind of a person who has come to you with something? So while you speak to the client, and eventually with the years of practice that you delve into, this will come naturally. You have to take hints while that client is talking to you, that what he's saying, whether that is the correct position in law or not, or he has assumed that that is the correct position in law and has done something. So you have to jot down those points and you have to take them out of that conversation. Now, unfortunately, I cannot give you a ready example of this conversation, but if somebody says something wrong, you can pinpoint. Even if somebody says something which is not correct and you see it as maybe I may have said something today which may be not correct legally, you can just go today, you can Google and see that the statement which I have said is not correct. So that is how you have to catch hold of your client while he is conversing with you, that what all he's saying and what all you feel he's saying is not correct as per your understanding, and probably interact with him at that point of time, or maybe in a follow-up meeting tell him that these things you had told me, but I feel that these things which you are saying are not correct as per law, and these are the repercussions that you might have. Now, when your client says what your client says at the very beginning is an important indication of how they are. Either they are negative or they are positive. Now, let's say, for example, they may say that you won't be able to help me, but someone told me that I should approach this particular lawyer. So these statements usually indicate that the client's understanding, what the client's understanding is regarding the law, regarding your competence. So you have to actually make these, because eventually a client will only pay you your fee and help you practice. So you have to, how you convert these negative statements and how you make a case for yourself is also very important. Now, you also have to analyze that if the client while conversing with you is associating with something which is altogether different and is not related to the case, you have to correct your client at that particular point of time, that this I think this is not relevant to the conversation that we are having, or not relevant to your case, and you have to bring them back to the table and actually get to the gist and bottom of the dispute. And if somebody is, if client is repeating themselves, so that doesn't help. You have to eventually find a solution. So that also you will find out while interacting with the client. And you have to have the ability to in general remember of what your grievance of the client was. You may not have to remember the verbatim because you are interacting with him verbally, or him or her verbally. So you have to just keep that in mind, that what your client's case actually was, to have a certain recall value, that if so today clients go to 7-8 lawyers, negotiate a fee, and then they come back to you. So if he or she has interacted with you and they come back to you after 7-8 days, you have to have that power of recall of what they said to boost a confidence in them that yes, you are the right person for the job. And you have to refrain from excessively degrading your client or protesting against your client, like we said, playing a devil's advocate with your client at the very first instance. Of course, that's a very good aspect, but after the client has uh, gained a confidence in you, and you gasp that the client has gained a confidence in you, you play a devil's advocate with the client, so that eventually all cases cannot be won. So eventually, even if you lose for the client, you can say that this is a situation which we had actually thought of, discussed with you, and this is what it has come down to. So please consider this situation, and that's how we have handled the case, so that it doesn't come that you as a lawyer were not aware of how to handle the case, or how the case could eventually lead up to. So you play devil's advocate, but at a juncture where the client is confident that yes, you're confident enough to handle their case. Now, the most important aspect of a client counseling is that you have to make the client comfortable. The person who's coming to you and interacting with you has to be comfortable with the fact that this person is handling my case, and this person is competent enough to handle my case. So that confidence will only come when the client is comfortable in your presence, is comfortable with your aura around him. That's when you do it. Then you prepare a checklist. Checklist, you have to keep it short. By checklist, what I mean is that you should know that if a client has come to you for a partition suit, what all information you require from the client. If he has come to you for an infringement suit, or if he and she has come to you with a family dispute of any manner, what kind of information do you want? That concise checklist should be there, so that it is easier for you also to prepare for the case. And maybe the client, sometimes they cannot articulate their case properly, but with the checklist being there and the kind of documents that you require being there, they may be able to help you better. Keep asking them questions. Keep asking them questions basis the checklist. If at all they are, probably hiding something, or if that particular information may not be in their knowledge, that would have come and they would have forgotten with the time. And then analyze, give them the solution, and go forward. But while client counseling, one of the most important aspect is that you should have and we should have a habit of listening. You should listen very carefully and catch on the aspects which are important for your case, and not miss out eventually on something which is uh, which is uh, which is very paramount to succeeding your case. And I would want to conclude client counseling by saying that as a lawyer, it is our duty to ensure that the client gets the best and nothing else. And the most important part of counseling is that you should be able to help your client to make the right decision. You should never let your client go in a wrong direction by knowing that you probably, by suggesting them something, are pointing them towards a direction which is not correct. And it is something which eventually will come with practice. There is no rocket science. There is no solution to it. But with the years of practice that you gain, client counseling will come naturally to you if you get into litigation or the other aspects of law which are involved, because at every stage some kind of a counseling is involved. Either it is with, if say for example you are an in-house counsel with the top management of your company, with the companies that your company is interacting with, the management of that particular company. So in all aspects this counseling is involved, and the end result is that how you make yourself better at counseling your case. So this is what it is. If somebody has any questions regarding this particular aspect, then I am happy to answer them. I think there are a few questions with respect to the first session which are there in the chat. I will just give me 1 second. So so Raj Srivastav asked that if is mediation necessary before filing a case. Like I said, it's only necessary in a commercial suit which comes under the commercial division, that is above 3 lakhs, but it has to be a commercial suit, not an ordinary suit. That is where it is mandatory, otherwise it is not. Then Nihal Singh says that, sir, as you mentioned, it is one of the speedy methods, but in some or the other way, after settlement is made and signed, then it again comes to the court and will be same as decree, then the party will file court for execution. The settlement will only become an execution if it is in form of a decree. Generally, in a money matter or in a money suit, settlement will have the process of payment. So if the process of payment is well defined, then that payment is done in that particular manner. So that is when the execution comes into play. So execution will come into play only while that matter has to be used. Now, why it will become a decree in the cases of partition, where in cases of partition you actually require a specific order of the court, because once that order goes to the court, that has to be informed to a particular tehsildar of your jurisdiction that this is how this partition is being done. That mediator cannot do. So in those cases it forms a part of the decree. So the in cases which are settled in mediation, the question of execution by way of decree doesn't come into force, because that settlement will have to is enforceable. Now if somebody doesn't enforce that settlement, then of course that decree part will come into the force. That is when that has to be followed on. But then that will also have other remedies with you of non-adherence of those settlement terms, so you can take those actions against the parties. Again, mediation is between parties. It really actually depends on the nature of the parties. If the party is a litigious person and they want to only litigate, then you cannot really help it. If mediation fails, the case goes to the court. Yes, it goes to the court. Sir, how a new lawyer can get the information about jurisdiction even before filing the application? Now, this all depends on which particular state you are in. So if, say for example, I can tell you about Bombay and Delhi. These are the jurisdictions where I frequently practice. So in Bombay, if you are residing in Dheri, then if that matter is below the pecuniary value of the high court, then you go to the particular district court, and if it is more than the pecuniary value of the district court, then you go to the high court directly. Same is the case in Delhi, that if for example you stay in the jurisdiction of Tisari courts, you go to the Tisari court. If it is more than the pecuniary jurisdiction of the Tisari court, then you directly go to the high court. Sir, if mediator is evaluating, how different is from affiliation? So if a mediator is giving a recommendation, that recommendation can be evaluated. Details can be evaluated, but of course they don't have to be followed. Conciliation happens between the parties, so the suggestions of the mediation are of course evaluative, but that suggestions have to be taken in a right spirit. They are not binding. So this is what I would say. So I think we'll end the session on this note. Rashmi, you can take this forward, please.
Yes, sir, absolutely. Sir, there is a question, if you may answer the same. Sir, you are on mute.
In the chat box?
Yes, sir.
Is there a time limit to file a case in front of the court, and that time limit has passed because parties were trying to they can still. So Pradipta, it's a very good question, but so what happens is that in the 12-way commercial court mediation, as soon as you initiate mediation, your the timeline of limitation stops. So the same is the case in a court facilitated mediation. However, in private mediations, that will not apply. If you were privately negotiating with a party, that mediation will not extend the time limit. But if it is a court guided mediation, then the time limit will be there. And under the Commercial Court Act, the act itself is very clear. Within limitation, you have to initiate the reference to mediation, and the limitation stops.
Thank you, sir. Sir, on that note, I would like to thank you.
Insurance matters also, mediation is there. Now these are all questions which would require another session, so I would not want to delve into. So that's about it. Thank you.
All right. On that note, sir, thank you so much for your kind time. You have given a lot of great insights to all of us. So thank you so much for that. We will be conducting a few polls for the participants on the basis of which your certification will be based. So I will ask you to stay back. But as I know that sir has another matter to attend to, so we give all of our best regards to you, and thank you so much for your kind time.
Thank you for having me. Thank you.
Yes, sir. Thank you. All right. So the participants can see a screen on their desktop, their mobiles right now. Bootcamp poll and quiz. I request all of you to kindly respond on the same. This will be the basis for the golden egg rewards for today as well. So please respond. Please engage on the same. Yes, everybody, please quickly. We will only be keeping it live for 2 minutes. It's already been 48 seconds, 49, 50. Quickly respond so that we can give you your golden egg rewards on the basis of the polls conducted today. You do not want to miss this opportunity. This will also be reflected on your certificates. So I request all of you to kindly engage, respond to the questions. Yes, we can see a lot more engagement.
Certificate will be providing basis of these questions.
Yes, the response rate is being recorded in our database.
Questions are not visible completely.
You will have to scroll down. Scroll down. Then only you can see the questions. We will keep this active for another 3 minutes.
Submitted.
Third
Okay,
question is
great.
Atul. There is nothing after that. Is Atul, what is the entire question? Is Atul, I'm not sure about that.
You need to scroll down. I don't think anybody else is having this issue. Yes, we are getting the responses, but most of the students are not engaging. Guys, your certificate will bear the grade on the basis of these questions. The same is being recorded in our database. So I request you to kindly answer, respond.
Ma'am, I have submitted today's question, but I think yesterday session were not same questions like today's one. So I have submitted by the Google Docs that have been shared on our WhatsApp group.
Sure. Whatever is you are responding to is going to be recorded in our database. Whatever you're not responding to is going to be recorded, and on the basis of that, your certificate will be provided. Yes, it has already been 3 minutes. This is the last minute. After that, we will be closing the polls.
Ma'am, can we get the recording of today's this thing? Because actually I did not know, so I joined a little late.
The recording will only be provided after the 3 days of boot camp. All the students who are active throughout the boot camp and on the 4th day of your career consultation day, the last day of the event, that is on Monday. All the people who are participating in all 4 days and responding will be receiving all of the recordings, certificates, as well as the reading materials. 80 students have responded so far.
Ma'am, can I get
83,
also
85.
certificate if we missed as one day to attend?
Sorry?
I think I have missed to attend yesterday's session for the few of the before.
I would request you all to kindly send all of your queries on your WhatsApp groups, because this will take a lot of time. We are here for the polls and the quizzes. There are a few more activities that we will have to conduct before we can conclude the session. So I will request whatever queries you have, kindly forward it on your WhatsApp group. It will be taken by a customer support executive. Thank you so much, Soumya. I am so glad you had a great experience with us. As I can see, most of you have responded. 99 students have responded so far. And on that note, only 30 seconds left, guys. Whoever has not submitted, please submit, because these are the last seconds that we are counting. The winner will be announced at the end of the day. Thank you so much, Ria. Thank you,
And
Anushka.
what rewards can get expect the winners on the golden egg basis?
It is always announced at the end of the day. Yesterday also, we did it at the end of the day. It will be done at the end of the day. Thank you so much, Anjali, Rakhi, Alan, Kanak. I'm sorry, your voice is a little interrupted. We are closing the polls now at this time. Thank you all the people who have engaged with us on the poll.
Ma'am, if I am not able to join the poll yesterday, then my certificate will be affected?
No, the same. Poll. Right, guys. Thank you so much, all of you, for participating in the poll. We are going to be conducting one more activity, after which we will be closing this session.
Ma'am, please share answers again.
Sorry?
Please share the answers for the poll again.
Bache, the same has been removed from the screen, so I cannot share it again. But you will be getting it in your certificate, so don't worry about that. If you do want, we can send it to you in your WhatsApp group after the end of the session, guys. On that note,
Yesterday I have not participated in the poll, so does it affect
all the
my
people who have
certificate?
not participated in the poll yesterday, the same will reflect on your certificates as well. Your certificates are divided into grades. So on the basis of that, your grades will be decided. So I request all of you to be active and participative in every poll and activity that is being conducted throughout the bootcamp, because it will be reflected on your certificates. I hope I'm clear. On that note, I have to start the next activity. I will take all the questions at the end of the activity.
But was not working.
What about this video?
Yes, we will be taking all of the questions relating to the class that we have just talked about. We are conducting a class on ADR. As you know that you are participating in this ADR bootcamp for 3 days. On the basis of the same, we will be conducting a 3-week class. What you just saw on your screen is the first teaser of that class. And for the same, yes, Somita. Yes, Somita, the live class is available as of now on the website of LEDX. We will be sharing the link with you in the chat box in a second. I want all the students who are interested in any kind of a mentorship program, our internship assistance program, our product consultation program. I want you all to participate in the poll that is coming on your screen right now.
Ma'am, I don't see any of the polls which is coming from the right going from my screen.
All right, guys, you will see a poll on your screen just now. I want all of you to respond to the same, after which we will be taking whatever queries are left after this
Ma'am,
session.
I don't see any of the poll.
I said you will see it. It is there on your screen right now. All right, as I can see that all of you have answered, we have the highest percentage of people who want to have more details about the course. I will take the next 5 minutes to convey what the course is all about. So the 20 hours advanced course that we are arranging on ADR will be conducted for a period of 3 weeks. 3 weeks, 3 days. So a total of 9 days will be conducted on ADR, in which we will be covering arbitration, mediation, conciliation, negotiation, all of the topics relating to ADR. The pertinent thing for you to know about in this particular advanced class is that, first of all, your certification will be coming not just from LEDX, but also from international and national organizations as well as law firms. You will be getting internship assistance from LEDX for pursuing an internship or career in ADR that you might be interested in. Thirdly, you will also be getting access to our mentorship program when it comes to building your resume in the field of ADR. You will be getting access to H5P assessment test, that is interactive assessment test, on the basis of which you will receive an industry verified certificate. After that, you will also be having access to to a bunch of reading materials, which includes a career prospectus on ADR, which you can access on our website completely free of cost as well. There will also be a brief of 250 landmark judgments in the past 10 years in the field of arbitration. You will be receiving 50 drafts based on ADR, 50 legal drafts based on ADR. So this is what we are planning on with the ADR course. You can sign up for the same if you are interested. And the most important aspect about this course is that it is going to be taught from the best of industry experts. All the people who are going to be there are going to be from international and national top law firms and organizations. So every single one of you who is interested in practicing and having an actual career in ADR must definitely consider this course, and we will be more than happy to provide you a consultation for the same. You do not have to go ahead and make a payment and purchase a course. But what you can do is at this point of time, you can have a consultation with us and we will give you all the understanding of what exactly is going to be there in this course. As you might also be interested in, all the people who are part of a boot camp are going to get a special early bird discount to this course, which is not available to the rest of the crowd out there. So all of you who might be interested in the same can drop a very simple answer on the poll that is there on your screen. If you are interested in a consultation, you want a mentorship counselor, or you want the link of the class, all you have to do is just respond on these polls. As I can see, most of the people want more details on the same, which we will be providing you. At the end of this session, you will also be receiving the link to this classroom that you can access, and we will be more than happy to give you the consultation that you require. On that note, guys, we will be ending today's session.
Ma'am, what is EDR means? EDR's full form?
Sorry?
EDR full form is what?
Alternative dispute resolution.
Okay, and how much the course fee is about?
As I said, all of these things you can access via our purchase consultation. That's not exactly something that I do. We have experts for the same. If you are interested, you can kindly call on LEDX and you will be able to connect with them. Is there any registration link of live class? Yes, Pooja, we do have a registration link for the same. We are sharing it to you in your chat box right away. On that note, guys, thank you so much for your time. We will be coming here again tomorrow to have another brilliant session with Jonathan, and we will be concluding the session on that. And then on the last day, we are going to have a whole career consultation session on alternative dispute resolution.